Recording. Penny, welcome.
Thank you.
I am going to share the screen, and as I said, Penny was working on this PowerPoint up until 4 o'clock today. So here you go, Penny. Just let me know when you want the slide changed.
All right, I will. Hello, everybody. It's lovely of you all to take some time this evening on this very, very complicated subject. I will try to make it as clear as I can, but I will tell you that this year of 2025 is turning out to be probably one of the most cacophonous years in the history of the Supreme Court, in the history of our judicial system, actually. And because so many things are happening in so many areas, it's really hard to pick out examples that make it clear what is going on in terms of the relationship between the court and the administration. I decided when I was asked to do this that I was not going to talk about the decisions that were made last June. Because, of course, those were all pre-Trump administration decisions. And I know that what people want to hear about and what they want to understand is what's happening now, which is quite different from what has been happening in the past. So let me begin the presentation with literally today's Supreme Court. As Lynn said, there is news every single day, and we will not be going down to that quite a granular level, but it's very hard to sort of bring it up to a level of any kind of generalization of what you can say about what's going on in the court right now. Everything is very, very particular and specific. So if you would, Lynn, you want to put up the first slide? Today we're going to be talking about, as I said, we'll do a little Supreme Court update for any of you who were in the class that the discussion that I had a year and a half ago. So we'll do just a bit of an update, and then we'll look at the major 2025 issues and cases that have come to the court through the auspices of the Trump administration. And then we'll talk about a few other topics if we have time, and I may have to skip through some of this. The power of case selection, the whole issue of the executive orders of the president and how they have changed the judiciary and what it does, and the shadow docket expansion and the major questions doctrine. So we'll try and pack in a lot. So Lynn, can you go to the next slide? The first thing we have to say is that we're talking about a court that just celebrated a major anniversary. In the first week in October this year, the Roberts Court was exactly, it's going racing through.
I'm sorry, let me just bring it through and get it back to the beginning. I apologize. I hit the wrong button.
Oh, okay.
So I do apologize. I was trying to admit somebody and accidentally hit the wrong button. Just give me a second. There you go. And okay. I won't do it again, I promise.
Here we are. So this first picture on the top there is of this was taken literally a few days after John Roberts became the Chief Justice. And as you will see, he's a very young looking man at that point. He hasn't aged very much, to tell you the truth, except that his hair has gotten gray. But what has changed are all the people around him. The Roberts Court is now almost 100% different than it was when he arrived. Only Clarence Thomas remains from that original court of 20 years ago. All the other players have changed. Lynn? Change at the court has been constant through the years that that the Roberts Court has been in operation. But during most of that time, And during most of the time before it, probably during most of our lifetimes, the court has been a 5-4 court. 5 conservatives and or 4 liberals, or vice versa. 5 liberals and 4 conservatives. It is split now into a very polarized 6-3 court, which is the first time in decades, as I said, that has been the case. And it doesn't sound like it would make much difference, 5-4, 6-3, but it does make a very large difference. In the first place, it is a polarized court. There are fewer justices that move out of their lane. In other words, the conservatives are really conservative and the liberals are really liberal, and they don't change very often. We no longer have a justice in the middle. Sandra Day O'Connor played that role for the 25 years she was on the court. She frequently moved from one side to the other. She called herself a conservative, but she frequently moved to the liberal side. Then when she left, Justice Kennedy a little bit took her position as a justice that could sometimes go one way and sometimes go on the other. But in general, the court that we have now are people who are very, very predictable in most of their positions. Of course, all of them from time to time do not stick with their team, as it were. But probably the most important thing is that it is far harder today than it has ever been for the liberals, for the 3 liberals on the court, to pull 2 votes from the conservative side. Pulling 1 vote is not always that difficult, but pulling 2 in order to get a majority is extremely difficult. Next. I wanted to show you this. I showed you this the last time, but the working environment of the Supreme Court is such a unique one. I'm sure all of you have worked in your lives, but I imagine not many of you have had this kind of an environment. These are 9 people who sit in this room and make decisions about the cases that are going to be taken by the court, and make decisions about who has won and who has lost those cases. And they sit there on Fridays, Friday after year after decade, and sit in specific chairs. John Roberts is down here at the very end, facing the fireplace, and then in order, going down by seniority, from side to side, all of the justices have their own seats. Ketanji Brown Jackson, being the newest justice, sits in the seat at the end, and it is she who takes all the notes, because although you see 2 chairs there in front of the fireplace, nobody ever sits in them. And that is because nobody sits with the Supreme Court when they are in deliberation, when they are in what is called in conference. They sit there, the 9 of them, alone, day after day, hour after hour, and work on the court. I shouldn't say day after day, because they usually just meet in this room on Fridays, but nonetheless, this is where the decisions are made. And it's a very, very unusual work environment. Lynn? So here are just a few random facts about the court. As we all know, under the Constitution, all federal judges are appointed by the president and cleared by the Senate. Once they are approved, they have lifetime tenure, and as a side benefit, they can't have their salaries cut either. It's in the Constitution. They can be impeached, however, but none ever have been. Although the United States created the first Supreme Court in the history of the world that we know of, and most other countries have followed our example, no other country has chosen to have lifetime tenure for its justices. All the other countries have decided that is too much power in the hands of too few people for too long a period of time, and have not gone down that road. We, however, have it in our Constitution, and as we know, it's almost impossible to amend the Constitution these days. So, Lynn, I think you jumped. I need to go back. Can you go back one?
Yeah, let me try. I'm sorry. I was admitting somebody from the waiting room.
Oh, I see. It's happening again.
Okay, I'm so
Okay.
sorry. It's what happens when you try to do it all. Okay, give me.
Multitasking is difficult.
It is, particularly with the, okay.
Next time it happens, I'll just skip over whatever it is because there's too much. It's the random facts. Yes. The most important thing that happens in this room is, or one of the two most important things that happens in this room, is that the justices have total control over the case selection. Every year, approximately 6,000 pieces of paper, the documents, about 6,000 documents come to the court and requesting that the court take these cases. So 6,000 cases a year come to the court wanting to get in the door for the judges to accept their cases. Only approximately 60 cases are selected each year. So that is 1%. And sometimes it's less than 1% that gets selected by the judges, by the justices. All of the others are rejected without any reason given. They are just simply told, no, I'm sorry, you don't get one of the tickets into the Supreme Court. Another thing that is interesting about this is that, of course, they used to take many more cases. When the Roberts Court started 20 years ago, they were taking about 80 cases a year. So there has been a 20% drop just since the beginning of the Roberts Court. And 100 years before that, it was 100 to 150 cases. So fewer and fewer and fewer cases are getting in the door. Lynn? So what is the power of case selection and why do they pick what they pick? Because this is such an important decision as to whether a case actually is even considered, why do they pick what they pick? Well, one of the reasons is that the justices are become interested in different subjects. There has been a dramatic rise in the number of religion cases that have been taken over the last 3 years. Last year, there were 6 major cases. The year before that, there were 5. The year before that, there were 7. But before that, there were maybe one every other year. So it was rare to have a religion case. Now there are really on a run with religion cases.
Hey.
Clearly, that is part of the desire.
Oh, okay. Tell me later because I'm listening to
Sorry, could you please
a
mute
webinar.
who's ever talking,
Yeah.
please mute.
Okay. I want to hear about it.
Okay,
How
I
Gabby's
just
doing.
muted that person.
Everything good?
No, I
Okay.
didn't mute that person. I'm sorry, whoever is talking, you need to mute.
In any event, why do they pick what they pick? So the religion cases. They also have the desire to overturn and control the lower courts. In the last few years, 83% of the cases that have come to the court have overturned what the lower courts decided. So clearly, when they disagree with something, they want to be able to fix that problem. A lower court has come to a decision that they are not comfortable with. There's also the desire to strengthen new doctrines that they have been creating. We're going to be talking today about the major questions doctrine, which was just invented in 2003. So it's a brand new doctrine and they want to use it. And the need to make time for an increasing number of the quick response emergency docket cases. The emergency docket or the shadow docket cases, as they are now called, are taking up at least 50% more time than they did just simply a year ago. So they there's still only so many hours in a week, and as a consequence, that makes them take fewer and fewer of the regular cases that they normally decide. Lynn? So we're going to be talking about the year 2025, but we're only going to be talking about, as I said, the cases that have come up as a result of the Trump administration. This is a historic legal challenge, period. And the second Trump presidency is the reason for it. And that reason, those reasons revolve around 2 factors. One is that the president is largely running the country by executive order. And secondarily, that as soon as he makes an executive order, people sue because they don't like it for one reason or another. And that immediately involves the courts, and there has to be a judicial response of some sort. So both the judiciary and the executive have been changed by Trump's governing style. Next. As I say, Trump is essentially ruling by executive order. He has issued 212 executive orders in the first 9 months of his presidency. These executive orders have done all kinds of things. They have eliminated a lot of things. They've eliminated congressionally mandated agencies. Whole agencies are gone. Programs and staff are gone. The Agency for International Development, AID, is no more. The Department of Energy is now reduced to just a few hundred people. The Voice of America, it's not just the big agencies, but also small institutions like the Voice of America are also gone, etc. They also have eliminated or tried to eliminate the 14th Amendment guarantee of birthright citizenship. They have not been successful with that, and that is still in the courts. So although Trump announced the elimination of that, it is still with us. They have been more successful in eliminating all transsexual rights to health care. There are now no more transsexuals. All the transsexuals in the military, I believe there are about 1,500 of them, were eliminated. In sports, their rights have been eliminated, identification documents, etc. So there's been a tremendous focus and tremendous success from this Trump point of view of getting rid of transsexual rights. And of course, they have gotten rid of a lot of people too through executive order. There are now 300,000 less federal employees and counting. And this, I believe this number does not include the number of people who have simply decided to take retirement or to leave the government because they don't want to work there anymore. The firing of congressionally mandated government officials without cause is another major thing that has been done through executive orders. The inspector generals were all eliminated the first week of the Trump administration. Every federal agency had an inspector general who was always looking for waste, fraud, and abuse. And for some reason, Trump got rid of these people. And the heads of independent agencies, et cetera, Lynn. They have been impounding and shifting congressionally appropriated funds across different government programs. The Congress is supposed to be the deciding factor in where appropriated funds go, and they do appropriate funds, but then through executive orders, they have been transferred and shifted around or eliminated completely. They have federalized National Guard units against the will of state and city officials in the District of Columbia, Los Angeles, Portland, and Chicago, and more cities are on the list and planned for in the future. They have been using U.S. military troops in American cities. The Marines were actually sent to Los Angeles. And Trump continually says that more regular troops will be placed in American cities in the future. And they have been imposing, of course, massive tariffs on almost every other country in the world without the consent of Congress. So what has been the consequence of these actions? As far as judiciary is concerned, they've been enormous. As of October 1st, there were 418 lawsuits filed against the Trump executive orders. 333 active cases were ongoing, were already in the courts, and 50 restraining orders on various parts, all or various parts of the executive orders were also in place, Lynn. The other issue that is contributing to the Supreme Court backup and total overload is the emergence, what used to be called the emergency docket and still officially is called the emergency docket, and the shadow docket. the shadow docket is just almost a pejorative kind of term, but the emergency docket was in the past a very different thing than it is today. Historically, requests for the Supreme Court emergency actions. Now, this is not the 60 cases that the court picks. This is a different group of cases where they want a quick answer from the federal judiciary. And these emergency actions literally can come from anywhere. You or I could ask the Supreme Court to do something on an emergency. We wouldn't get very far, but we could ask them to do it. So individuals, corporations, associations, states, federal agencies, the lower courts, prisoners, and presidents can all ask the Supreme Court to take an emergency action. And these actions are usually to request a stay. And a stay is simply a temporary stop to some kind of impending or specific action. Its primary past use, when the emergency docket had its old definition, was to stop an execution. It was very common when someone was going to be executed for the day before the execution for there to be a one last effort letter to the Supreme Court asking them to stop the execution on an emergency basis. Whether it's an execution or any other kind of emergency action being requested, it is usually denied. Almost all of them are denied. The court doesn't grant any kind of a hearing in this denial. They don't review the record. They don't give any kind of a vote count if it gets far enough for them to actually have a vote count among the 9 of them. And it is almost always dismissed with a single sentence. The application for whatever it is you're asking me for is denied, period, end, it's done. If it is granted, however, these requests then, because it's granted because it's some kind of an emergency, and therefore they jump over the regular cases that the Supreme Court normally works on. And they are dealt with some immediacy by the Supreme Court, and you get a decision, but there is no review of the record. There's no public hearing. It's just the Supreme Court either takes or doesn't take the action that you want it to take. But things have changed, Lynn. Presidential use is expanding, and that presidential use has made all the difference. I will give you some comparisons. The number of presidential emergency stays or shadow docket requests are hugely different from the past numbers. In the Bush and Obama administration, both gentlemen had 8 years in office, and they only asked for a Supreme Court intervention 4 times. So sort of once every other year. And the Supreme Court only granted them what they were asking for 2 times. So they each had a 50% record. Donald Trump came in his first administration, and he asked 41 times in the 4 years that he was in office. And during that time period, 28 were granted, a 70% win rate with the court. Biden then came in and asked for half as many as Trump had done before him, less than half, slightly less than half as many in his 4 years in office. 19 times he asked, and 10 times the Supreme Court granted him what he wanted to have happen. And then we come to Trump 2. And there have already been 29 times in the first 9 months of the Trump administration where the Supreme Court has been asked for an emergency action. And of those 29 times, the Supreme Court has granted the president what he asked for 21 times and only denied him 3 times. So the win rate right now for the Trump administration is an 84% win at the Supreme Court. So we come to this year with an increasing use of the shadow docket for major, largely unexplained decisions. And that just the fact that that is happening, that there are so many emergency decisions now being made by the Supreme Court, and that they are so often positive, as far as Trump is concerned, has become a very controversial thing, not about him, but about the Supreme Court's response to his executive actions. Lynn. So we will talk, and I'll move through this rather fast because there are too many of these, even though I've cut it down to just a nubbin of what the real volume would be. The Supreme Court shadow docket orders, these are on the subject of congressionally mandated and funded programs. So these are programs that the Congress has worked through the budget, actually produced a budget, produced a decision on how the budget will be structured and funded these programs. I will immediately state that we are not going to talk about immigration at all in any of its forms and guises because we would have a whole 2 hours just on immigration. So we're not going to be talking about that one, but we're going to be talking about other congressionally mandated and funded programs. In February, there was an executive order to suspend $2 billion in foreign aid payments for completed work. So this is where the AID had spent money abroad on programs that had been funded by the Congress. The work had been completed and the bills were sent to the government for payment. The executive order said, we're not going to pay you, period. In March, the payment was reinstated by the Supreme Court. So this is one of the three where they turned him down. The payments were demanded and they were actually paid. At least I have heard that they were actually paid. And this was a 5-4 decision. And the three liberals were said, you know, the government owes these people the money. They've done the work. We have to pay the money. And they were joined by Justice Barrett and by John Roberts himself. So it was a 5-4 decision. Justice Alito wrote a dissent in this decision. Usually emergency docket things are moving so fast through the system that they don't generally have dissents, although sometimes they do. And Alito said that he was stunned by this ruling and that the liberals and Barrett and Roberts had imposed a $2 billion penalty on American taxpayers. But the liberals, Barrett and Roberts, said, you know, we owe these people the money. The United States pays its bills. So that's what that decision was. Another example of this, though, having to do with foreign aid, is that in September, Trump did a pocket recession. In other words, he just simply let the year run out and didn't spend $4 billion of appropriated foreign aid funds. And that was allowed by the Supreme Court. It was challenged and it was allowed by the Supreme Court 6-3. The New York Times commented on this case. He said they said this allows expansion of the presidential power in a preliminary test of Trump's efforts to wrest the power of the purse from lawmakers or from the Congress. The Congress is the one that is supposed to appropriate funds, not the president. And when those funds are appropriated, they're supposed to be paid, not necessarily. Lynn. So let's now talk about Trump program suspensions. And this is just one of many, many, many programs that have been suspended. The agency that I worked for, the Environmental Protection Agency, has gotten rid of just tons of them, just that one agency. So this is an example. This was a congressionally mandated Department of Energy teacher training program that was to happen in poor and rural communities. And it was eliminated by a Trump executive order. His objection was that it contained DEI provisions, and he does not like DEI provisions. 8 states in this case sued in federal court, and the district court judge temporarily suspended the program elimination and said, you can't eliminate these, pending the Supreme Court's decision, and they went in for a decision from the Supreme Court. On April 5th, the Supreme Court overturned the lower court's suspension and the program was allowed to end. This was a 5-4 decision. The reason given was that the 5 justices believed that the states would continue the programs on their own, and therefore there was no need for the money to go through this program. The Roberts and the 3 liberals objected vehemently, saying Congress had made the decision that they wanted to fund this program. It didn't matter that the states might continue it on their own or they might not. So this was another example of in a 5-4 decision of the Supreme Court essentially going along with the president. Just as a side note, in March, the president also announced that he had decided to eliminate the entire Department of Education, and he has gradually gotten rid of more and more and more people and programs to eliminate a whole department of the government. The departments of the government are created through congressional laws. So once again, this is a congressional power that is being essentially taken by the president. Lynn?
Recording in
Um,
progress.
He also has been firing independent agency members. Numerous independent agencies have been created in the government, and they have been made independent so that there would not be political ramifications. Oops. Here we are. The president can only fire 5 members for non-performance or malfeasance. The president wanted to fire 5 members of these independent agencies, but he did not put forth, I'm sorry, I'm saying this backwards. What is the law concerning these independent agencies says that the president can only fire the members, any members of these independent agencies for non-performance or malfeasance or graft or some other crime. In other words, the president has to have a stated cause as to why he is firing somebody, and it has to be a pretty serious offense. The constitutionality of this form of independent agency governance was confirmed back in 1935 in a case called Humphrey's Executor. So it's not a new idea. These independent agencies have been around since the 30s. But Trump went ahead and fired 5 Democratic members in 3 different agencies without stating any cause at all, much less a serious cause. There were numerous challenges, and the lower court stayed. A lower court stay was put in place. Lynn? On the 23rd of September of this year, however, all lower courts in this having to do with this issue were overturned by the Supreme Court. In other words, the firing of these people was allowed to happen. And one of these cases was taken, one newspaper article said grabbed, by the Supreme Court without any kind of a lower court hearing or finding. That case is going to be heard by the court on December 8th. The case is called Humphrey v. Slaughter. It is now one of the major cases of this year because hundreds of the status of hundreds of agencies hangs in the balance, and it is a major balance of power case between all the 3 major parts of government. The questions being asked in this case are, should the court overturn Humphrey's executor because it violates the separation of powers? In other words, does it give Congress too much power by saying that the president cannot fire these people at will, or should that be the executive's power? And then the second question pits the executive against the judicial branch. Does the court have legal power to prevent a president from removing a person, any person, from public office, without question. So we need to move now to the birthright citizen issue, another major issue under this general heading. This is the guarantee of birthright citizenship found in the 14th Amendment of the Constitution. I think we all know about that. Trump issued an executive order in his first day in office saying that that was no longer the case and that one parent had to be a citizen for every baby born in the United States. They did not automatically get citizenship unless one parent was a citizen. This was challenged by many states across the whole United States. Obviously, the states are the ones who give birth certificates. And that becomes a very difficult problem if you have to establish whether one or the other parent is a citizen of the United States. People generally don't go to the hospital with their birth certificates, the parental birth certificates in hand, so that they can prove that they are citizens of the United States. And certainly it goes against the very idea that any child born in the country is a citizen, which is what the 14th Amendment actually says. Numerous lower courts issued national injunctions all over the place, and it was immediately stopped. All of those were eliminated by the Supreme Court, however, on the 27th of June in a case called Trump v. Casa. But they did not address the birthright issue. This is a very odd but a very major decision. What they addressed was the fact that all these lower courts should not be doing national injunctions. They moved this case from being a birthright citizen case to being a question about national injunctions. And the Supreme Court has long disliked lower courts making these kinds of national decisions. And so they eliminated that in this case. But since there was no decision on the birthright citizenship, it was immediately, by the way, overturned by the Ninth and the First Circuit, who figured out a way to get around the Supreme Court's ban on national injunctions. We won't talk about that. But the main point is that the Supreme Court has not acted yet on the Trump now question, has gone to the Supreme Court about birthright citizenship. Can he make this rule of one parent must be a citizen a national rule and overturn the 14th Amendment or reinterpret the 14th Amendment? And that case has not been either accepted or settled yet. Everyone knows the Supreme Court has to accept it at some point, although national injunctions, although they're supposed to be temporary, they can go on for years and years. So it could be quite a while. Lynn. Then we have the two really big issues that I hope we will have time to talk about. How am I doing for time? The first one is the use of the military in American cities. The administration basically alleges that crime-ridden Democrat cities require federalization of state National Guards, that just simply local police forces are not making it. The cities are running amok, and therefore there has to be a federalization of state National Guards to handle these urban problems. They particularly focused on the facilitation of urban ICE deportation activities, which are not popular in major cities. The basic law that controls where the military can and cannot go was put into effect in the Posse Comitatus Act of 1876, long time ago, 150-year-old law, and it generally prohibits the use of federal military for domestic law enforcement. It says the Army can't go into the cities, basically, or the Marines, or anybody else. Military domestic law enforcement. In 2006, there was an amendment to this act that allows the federal government to request the use of state National Guards in both the where the Guard resides, the state in which it resides, and take it to other states as well. If there's a real emergency, the president can request such a thing of the governor of the state. If the president doesn't want to make the request, or he knows that governor is going to turn him down, he must invoke, according to law, the Insurrection Act to go alone. The Insurrection Act has not been used by a president since Dwight D. Eisenhower was using it to desegregate the schools in the 1950s. So it has not been used by anybody, and it has not been used by Donald Trump yet either. Lynn? We have situations. In Los Angeles, the military has definitely been used. 4,000 California National Guard troops were federalized by the president without the permission of the governor. And in addition, 700 military Marines were deployed in June. There are now only about 300 left, and the whole situation in Los Angeles has calmed down. But this was the first place that moving the troops into the cities, which is something that Trump has stated he wishes to do. And many people have commented that he wishes us to get used to the idea of having troops in our cities. At the 2nd of September, a federal judge declared it a national police force, what he had done in Los Angeles with this 4,000 National Guard, and that it was illegal, and determined that they could only stay to guard federal buildings that are present in the city of Los Angeles. I don't know whether that has been carried out or not. Then, of course, here in the District of Columbia, we had 2,300 National Guard mobilized to handle our terrible problems, according to the executive order. 900 of them were from DC, and the rest were from 6 different southern states. So parts of National Guards in 6 southern states were sent to the District of Columbia. They actually arrived, and it was authorized for them to use guns. Trump has wide power over the National Guard in the District of Columbia, as opposed to any place else in the country. And they are still here. I saw some just recently at a metro station down near DuPont Circle. Just as a side note, the state of West Virginia is one of those that was brought into DC, and they are now suing the government to get their own National Guard back from the District of Columbia. And then we have Portland, Oregon, which Trump called a war-ravaged city. The governor and the mayor call that allegation absolutely ludicrous. Trump then federalized 200 Oregon National Guard, but a federal district judge immediately blocked that order. So on the 20th of October, the Ninth Circuit, and the Ninth Circuit is the circuit that is over the state of Oregon and the whole West practically, overturned the lower court ban. But then on the 24th, it temporarily put it back in place. I'd say, are we having fun yet? This kind of cacophony of it's in place, it's out of place, is happening in all of these cities. Lynn. In the city of Memphis, we had a slightly different situation, and that was a situation in which the governor of Tennessee actually asked for federal intervention. And so they federalized the Tennessee National Guard, and they deployed it at both the invitation of the governor and of the mayor, and they actually paid the federal government $100 million to do this. There were stipulations, however, because they were being nice and cooperative. They got to put stipulation on what these troops could do and how they had to look. The troops had to be in uniform. None of this, people walking around in vaguely militarized clothing without any identifications. So they had to be in their normal uniforms. They could not wear guns, and they could not be masked to do any of the functions. But there was no declaration of emergency. So we'll then go on to San Francisco, where Trump had been putting together a group of people that were going to take over San Francisco. And they've been working on it apparently for several months to put together a team that they would federalize. But the Trump administration got a call from a few billionaire donors from San Francisco, billionaire donors, and they wanted him to back off. He got the telephone call on October 22nd, and he made the decision the next day saying, we won't go into San Francisco after all. Next. The big one is Chicago. And this is where a major Supreme Court decision that will be made, and it will be probably a historic decision. This started with the governor and local officials vehemently refusing to have Trump Trump had ordered the use of 300 federalized National Guard troops to go from Texas to Chicago to work in Chicago to, quote, assist local law enforcement. On the 9th of October, the federal district judge blocked that deployment, and that blockage is still in place, although somehow through some mechanism there are some soldiers there. I haven't quite figured out this one yet. The law allows the federalization of the Guard to suppress a rebellion, but there is no credible evidence of a rebellion taking place in the state of Illinois. So the president just simply making a decision that there's a rebellion because that is the law of the Posse Comitatus Act. It says the president can do this if there's a rebellion. So there's no evidence of a rebellion. The Seventh Circuit, which controls the state of Illinois, the federal district in Illinois, agrees and they with the bloc and calls the use of the Texas Guard an incursion on Illinois sovereignty. I should say that the troops that are actually there are from Texas. So I don't quite know how this is happening since the Seventh Circuit has already spoken on the issue. Lynn. However, it has now been converted into a federal case, and this is now a full merits docket case. The Trump shadow docket request asked the Supreme Court to remove the block. The Supreme Court then ordered briefs from both sides in a major balance of power issue. So, day before yesterday, last Monday, the briefs were presented to the Supreme Court. So it is now in the hands of the Supreme Court. And the Justice Department said that there is a strong tradition of using the militia rather than the standing military. They don't want to send in the standing military, but there is a domestic disturbance that demands that they use somebody, so they want to use the soldiers from the state of Texas. They went on to say that the court must grant extraordinary deference to the president in the exercise of his commander-in-chief power. And here is the big one. This is now stating that Trump simply by being the commander-in-chief does not have to come under the Posse Comitatus Act, that his simple status as commander-in-chief allows him to put soldiers of whatever kind wherever he wants to do so. They're not stating it that boldly, but that's sort of what it boils down to. On the other side of the issue, Chicago and the state of Illinois is saying that they can't do that, that the regular forces that are used under the Posse Comitatus Act refer to the United States military and not to the National Guard. and that a reading of the Chicago situation as an invasion or a rebellion is just ridiculous. It is not an invasion, and it is not a rebellion by any definition of those two words. So there will be a decision in about 10 days, supposedly, to this very, very important question. So now getting quickly to the tariffs. I think I'm running out of time here. Am I, Lynn?
You're actually fine on time, because you volunteered to stay a bit extra for questions, so don't cut yourself short, please.
Okay. Tariffs have been much in the news for a wide variety of reasons, not just having to do with the Supreme Court. These other subjects that we've been talked about are largely talked about under the umbrella of the judicial system and in particular the Supreme Court. But tariffs, of course, have dominated the news since Trump started putting them out and covering the whole world. In April, he actually imposed the first tariffs against our friends, Canada, Mexico, European countries, etc., and then began to take on our foes as well, Congress and China and most of the rest of the world. In August, there was a 7-4 ruling by a lower court, not the Supreme Court, that said that his justification for the tariffs, which he stated was in response to a law, the International Emergency Economic Powers Act, had been imposed unlawfully, that he could not use this law as the basis for these tariffs. Now, we all know that the tariffs are changing the economy, not just of the United States, but of the entire world. And so it was a great shock in August to have a lower court rule, in this case, a circuit court rule, that it was an illegal action by the president. This court said that the power to tax resides in the Congress. And indeed, that there is no proof of any kind of an imminent threat by these other countries against the United States that would allow the president to exercise that right even on an emergency basis. So the 1977 Act, this act was done in 1977, to deal with any unusual or extraordinary threat to national security, foreign policy, or the economy of the United States, does not mention tariffs. It doesn't mention taxes. Among the tools that the president can use to address an international emergency under this law, these things are simply not found. So the Supreme Court had a hearing, and the major questions doctrine was definitely raised at this hearing, and many people were thinking they would take the position that it doesn't apply to presidents, because the way it has been articulated by the Supreme Court in the past, this new doctrine, major questions doctrine, has been only put forth in the context of the Congress and the courts. Lynn. So we now have this big mega case, learning resources versus Trump. This is now no longer a shadow docket case. This is now in the full court. On September 9th, the Supreme Court takes the tariff case, and this case was brought by 5 small businesses in 12 states challenging the legality, and it is, as I said, a full merits docket case. And on November 5th, just last week, they had the hearing. Normal hearings of the Supreme Court last an hour or a little over an hour. This one took 3 hours. And the relevance of the major questions doctrine was very hotly debated in this hearing over the course of the 3 hours. At least 3 of the conservative justices, Justice Gorsuch, Justice Barrett and Justice Roberts, appeared to agree with the liberals in this case and showed great skepticism over the legality of the president's power. As we know, the justices go into that room on Fridays and they vote around that table, and they know probably at this very minute who has won and lost this case. And the ramifications of winning and losing this case are absolutely enormous, not just for the United States, but for the economy of the entire world. I'm very glad that I'm not one of those people sitting in one of those 9 chairs, because this is a decision of such importance that everyone assumes that the Supreme Court is going to come out with a decision much faster than they normally do. Usually a case law of this magnitude would not be released until the last day of the session, which is the last day in June. But a lot of people think it will be released much earlier than that. So we will see whether that happens or not. Lynn? So I probably should tell you right now what the major questions doctrine is. In simple language, it is, and this greatly oversimplifies it, but on issues of, quote, vast economic and political significance, vast economic political significance, neither Congress nor the courts can defer decisions to a regulatory agency or to an agency of government. So if it's a big, huge, humongously expensive thing, and this was, by the way, applied to Joe Biden's desire to alleviate college loan debt, the Supreme Court used this major questions doctrine, and basically they said, this is just too big and expensive for the president to sort of extrapolate the fact that he can do this. It has to be put forth under a law by the Congress. But the question is, how and when does Congress establish the threshold for what is a major question? Is it over $10 billion? Is it over 40 million people? What establishes something as being a major question? And the further question is Congress even the one that will make this kind of decision? Or will it be the Supreme Court that makes this kind of a decision? So this very, very new 2-year-old doctrine is now bearing great weight in many subjects, but probably this is the biggest one of all. Are these tariffs and this whole reshaping of our economy and the world economy going to be declared not applicable because they do not comply with the major questions doctrine of the Supreme Court of the United States? Does this apply to presidents or doesn't it apply to presidents? Is at the core of this decision, because there is no doubt that this is a major question. Absolutely, it's a major question, yes. And that is going to be a constitutional issue of enormous, enormous consequence. Lynn? So, where are we with the Supreme Court? They've had 20 years of the Roberts Court, and there have been all kinds of dramatic changes, including almost a complete turnover in staff of the court. There has been huge amounts of growing conservative power, and the conservatives now control 6 of the justices. Shall we say their political predilection and their judicial predilection is toward the conservative side of making decisions. And it's a very activist court. By anybody's definition, it's a very activist court. And now, on top of that, we have this massive Trump factor going on, which is taking lots and lots of norms and just throwing them up in the air, and they are landing where they land. So how far back because conservative courts are ones that want to go backward in time. How far back is a conservative court likely to move us? They could move us back to pre-Obama, and that would, by eliminating things like the Affordable Care Act, the climate change laws that came in during the Obama administration, state and local gun controls, which also came about then, and gay and trans rights, which expanded during his time in office. Pre-Johnson, during the Johnson administration, there was the Voting Rights Act was passed, and the Supreme Court has already limited the Voting Rights Act enormously and will probably almost end it during this session. They have a case that would do that. But also, Johnson was responsible for Medicare and Medicaid, and there are many people in the conservative community who don't like that one. But there's also pre-FDR. FDR put in Social Security, the minimum wage, the whole idea of national welfare, unemployment insurance. There has actually been talk in newspaper stories about changing the child labor laws and moving them backward. And then, of course, pre-Teddy and Teddy Roosevelt and Wilson, they were the ones who brought in the administrative state and created all sorts of new government roles, and the non-political civil service, which Trump appears to really like the idea of having a political civil service instead of having a non-political civil service. So the wild card here is, will Trump further empower court conservatives to support all of his plans, or will he force the court into a constitutional defense position? And that will probably differ from subject to subject, but it could be that we're in a situation where these kinds of changes, either backward or forward, or even staying in the same place, will have to be decided by 9 people sitting around that table, which is truly incredible. So last slide, I think, Liz. When people ask me all the time, do you think we're in a constitutional crisis? Or how will we know if we are in a constitutional crisis? The experts say that the line will be crossed when the Supreme Court orders a major action in response to a Trump executive order that the president refuses outright to honor. The Supreme Court says do it, and Trump says no. But there are many Americans who think we are in a constitutional crisis now, just simply because of the decisions that are being made that I have very briefly outlined in this talk. So I will open it up now to questions, and we can see if anyone, by the way, if anybody wants a black and white copy of these slides, just write me at pennyhansen@aol.com. No E in Hansen, Hansn. And I would be happy to send you a paper copy of these slides. And they are 6 slides to a page, so it doesn't take much paper anyway. So let's open it up to
Penny?
questions now.
Yeah, Penny, with your permission, if anybody emails me, can I forward the slide deck? since
Oh,
you had sent it to
absolutely.
me?
That would be fine. If that's an
Sure,
easier way
okay.
to do it, that's fine.
Yeah. So feel free to email me at Georgetown Village, lynn@georgetown-village.org. And with Penny's permission, I am happy to send this to you. That was an amazing presentation. We've been doing these CCC programs since the pandemic. And I have to tell you what, not only do I think it's amazing, but I've been watching our participant count, and you haven't lost anybody during this presentation. Usually, sometimes, people will drop off after half an hour or so. Everybody's still here. So let me see if we have questions. Please raise your hand either electronically or physically, and I will look around the room. And be sure to unmute if you have a question, because I did mute you all after somebody got a phone call.
How many people do we have, Lynn?
We have 23. Yes, we have 23.
Good.
So are there any questions for Penny? I know she covered a lot of ground, and it's all been fascinating and things we're very interested in. And so if you have a question, please raise your hand, unmute. Penny is happy to answer them. Emily, is that your hand? Yes, thank you. I'm going to ask you to unmute. And we have a comment saying it was a fabulous session. Thank you. Emily, I'm sending you the unmute button, please.
Emily, I'm glad to know there are other people that can't find their unmute button.
Found it. Thanks to Lynn, I found it. Thank you very
There you
much
go.
for a superb presentation, a superb and somewhat discouraging presentation. I'm
Yeah.
wondering if you have any prognosis for what the decision will be, at least on the tariff issue. And then we'll leave it at the tariff issue for the moment.
Well, I will tell you, I like most of the other people that I've seen commenting in the Times and the Post and online. I had exactly the same impression that I was stunned at how positive sounding in my interpretation of what is positive, the three justices were. Robertson and Gorsuch and Barrett all were making comments like, I don't think this is legal, or asking questions. I shouldn't say that, they don't make comments, but they were asking questions that were probing very deeply and showing great skepticism for Trump's adoption of this power to lay taxes, tariffs. And I think everyone was kind of stunned that this happened. No one was stunned that the case took 3 hours. And no one was stunned that they really at the arguments that were made. But everyone was really stunned, I think, with how those three justices responded. And even the justices that were on the other side of the issue were not very passionate about it. They didn't seem, I've listened to a lot of these cases, and they didn't seem nearly as incensed about this or committed in any way to the tariffs subject. So, it came out being a lot more even than I thought it was going to. Emily, I really, I have no idea what's going to happen. Nobody does at this point, but it is fascinating. This was one of the most interesting court hearings I've ever heard.
Thank you. Fingers
Thank you.
crossed for a good
Thank you.
result.
So we had a question in the chat, Penny, from Lori asking, what do you think the effect of the Trump administration's attacks on major law firms has been on the cases and the quality of representation before the Supreme Court? That's a good question.
That is a good question. I'm not a lawyer. I mean, I do this class primarily because we have at Ollie lots and lots of smart people who aren't lawyers and want to know about these things. So I'm sort of an interpreter, but I'm not myself a lawyer. So it seems to me, I will say very candidly that I think the last Solicitor General we had, speaking for the Biden administration, Elizabeth Proligar, was without a doubt one of the best proponents of her points of view that I have ever seen. And she would be a really tough act to follow. And I think the present Solicitor General is not really in her league. I'm sure he's a very good lawyer, and he is maybe a lawyer's lawyer. But in terms of listening to him make arguments, she is a much better proponent than he is. She was a much better proponent than he now is. So that's the only thing I can say about the quality of the representation of the points of view. I think the questions coming from the justices are very good this year. I mean, they're getting right to the nub of the matter. So the justices themselves are doing very well at their hearings, I think, in general.
Thank you. Thank you. Hans, did you have a question? I see
Yes,
you're
I do.
unmuted.
I'm unmuted.
You are,
Um,
yes.
Yes. Thank you for a very interesting summary of the court actions. The question I have is, do you have any idea whether the concept of term limits or age limits for the Supreme Court will come up at some point?
Oh, absolutely. It has come up. The problem is, well, let me say that during the Biden administration, they had a major full court press to bring these issues up and to try and get some national consensus on whether people preferred term limits versus expansion of the court. That was the question. And the bottom line was that the American people, because there have since been surveys on this, the American people came out just about where most of the participants in this Biden exercise did, and that was firmly on the side of term limits. That just simply adding people to the court would result in a kind of tit for tat. One president would add two or three people. The next president would then get a law passed by Congress to add two or three people, and it would just be a mess. But the idea of 18-year term limits was very seriously considered, and I am vehemently in favor of it. And term limits are the methodology that most other countries in the world use. And 18 years is quite a common amount of time. And the whole idea is then that would roll over, and each president would have two justices, because they would stagger them so that each president would get. And to me, that the benefit of that is that the American people are expressing their desire for certain, shall we say, philosophies of governance when they choose a president. And so if every president gets to pick two justices over the course of his presidency, then that is a very good, could be expected to be reflective of the views of the American people. So it would bring in some small element of democracy to the process. So I'm vehemently in favor of it, but the position has been taken by many people that you would have to have a constitutional amendment. I personally do not think you would have to have a constitutional amendment to pull this off, but it's because more people think you would. And of course, we just don't do constitutional amendments anymore. We haven't done a significant constitutional amendment for 50 years. And it's not because Congress doesn't put them in the hopper, because constitutional amendments get presented in the Congress all the time, but nobody ever pays any attention to them because they know they're never going to pass. So
such
we're
an
sort
action
of, we are stuck kind of with the Supreme Court that we got.
So such an action would have to start at the Congress, the House, the Senate? Who does it?
Yes, to amend the Constitution, you have to start in the House and Senate. No, there is one provision that if 3/4 of the states, I believe, can petition the government for a constitutional amendment. But getting 3/4 of the state to agree to anything, much less words of a constitutional amendment, would be like a miracle. So we are in a difficult position because we really are stuck with a constitution that needs some change. But we just don't seem to, but amending it isn't working. Nobody wants to have a constitutional convention because it would turn out, I mean, if we can't even get the budget done, how are we going to have a constitutional discussion? So we're kind of stuck, Hans, with the Supreme Court situation that we have, sadly.
Thank you.
Thank you. Thank you very much. Are there any other questions? And if not, again, I thank you, Penny. Michael, I thank you for helping to arrange these programs. As I mentioned earlier, Penny teaches for OLLI. So if you're interested in more information, Penny was sharing with me earlier that some of the OLLI classes are now also online. So for those of you who don't like to have to get out, you're welcome to look at OLLI online, OSHA Lifelong Learning Institute, and find out about their classes. On behalf of Georgetown Village and our board, we are happy to offer these programs to our community. And we do hope that you will think of us when you make your end of year donations. We don't request payment for these programs, but we certainly do offer them as a community service. Thank you, everybody. Have a nice evening, and we look forward to seeing you at another program or come to the village, join us. Have a nice evening.
Thank you.
Thank you.